Welcome, everyone. I'm glad you're back. I see everybody hanging out in the chat. So I figured this our little Sunday night hangout. People have been sending me comments. Some that email me, been sending me emails. They're like, "Where you been?" Because I didn't put anything up for a few days. I kind of did a little bit of running around this weekend. So that's the only reason why you didn't see anything for the past couple of days. But I'll be back on schedule as usual. So as you know, hold on one second. So as you know, I've been following the case in Nevada with the sovereign citizen that's in there. Just guess the usual. So just to give you a heads up. So it's from our Nevada judges. And I do have something in the description on them because they do take donations for their site. They kind of do their own thing in the courts. And I didn't know that at first, but um I think they do a really good job. So some people was asking me about, well, was commenting me about the pop-ups on the screen. I can take no credit for that because I didn't do that. But on some of my other videos, I may start doing that. It takes a little bit of time, but we'll see. So I wanted to make sure to get a shout out to that. So you can check in the description on that, and the channel source is in the description. So I see one person here tonight. Now everybody's special, but I have to say something about this person right here. Cool, clear water. I'm glad you made it and to check things out. So thanks for coming by. All right, let me oh, so actually we have two hearings tonight. One from there that I already mentioned. And for those of you new to the live stream, it's been on the regular channel, not live. And then we have a case out of Judge Webster's court. We'll talk about that when we get to it. But I'm gonna go ahead and start this one off, and I think we are ready to go. Let's do it.
Charles Goodman, 14879 for Mr. Sachs.
Shadow 4740 signal from Ms. Zhang.
And we have Ms. Lang and Mr. Saxon are both present via Zoom. This is the state's notice of motion and motion to continue trial and state's motion for discovery. There was no opposition per se that was filed by either of the defendants. However, there was an affidavit that was filed, a 43-page affidavit with multiple pages of additional articles and exhibits that were attached, that was filed by Mr. Sachs. Mr. Sachs is currently represented, and he again filed it as attorney-in-fact Sachs, which I have explained to him on numerous occasions that he cannot call himself an attorney-in-fact when he is not a licensed attorney. He did not file his affidavit in Ms. Zhang's case. He did file it in his case. However, ACR 7.40 says when a party has appeared by counsel, the party cannot thereafter appear on the party's own behalf in this case without the consent of the court. By filing an affidavit, and I need Mr. Sachs, if you are currently typing on the computer and have your volume turned on, I need to put yourself on mute because I can hear it in the background. To the extent that the affidavit was filed, it's not an appropriate opposition, obviously, it's not an opposition. However, there were things that were stated in it that in substance appeared to be an opposition to the state's motion.
Now I'm gonna say something real quick about that affidavit that was filed. So in the last hearing, I asked the question of how long will a lawyer last on this case? And then seeing that this is going on, I was like, I don't know if the lawyer's gonna last too long. I know he's using a lawyer for right now, but that may change. And also, really quickly, I have Eric. Eric, thank you for being here. I mentioned everyone here, but there's reasons why I'm mentioning these people that I can't really disclose here, but they know why I'm calling them out like that. So, Eric, I'm glad you was making it in here. But yeah, and everyone else that kind of popped in afterwards, I appreciate you coming in. I see Brecken has stepped in and giving all a bunch of hellos and everything. So, all right, let's keep moving with that. I just wanted to throw my comment on that one. Let's go.
And would be inappropriate for Mr. Sachs to file since he is currently represented by Mr. Goodwin and did not obtain consent of the court to file that affidavit on his own behalf. So I would like to address that issue first before we even deal with the issues as it pertains to the motion to continue the trial.
May I address that? Your Honor?
You may.
So, Your Honor, the affidavit,
Your Honor, the defendant is holding up the sign.
what he's saying is while the interpreter is speaking, he cannot hear what the court is saying. I would guess that's because of how the volume works with that. Austin, do you have another? Well, no, I guess that wouldn't fix the problem because of the.
Well, we don't need an interpreter. This is a real problem here because I basically heard nothing what the judge said. I heard nothing.
Okay, well then I will repeat myself so that you can hear it.
And you just need to summarize this briefly.
You can summarize, that's fine.
Austin, we're going to be speaking on the affidavit.
If they need an interpreter, I say. If they don't.
We don't need an interpreter.
CC, is that correct?
你要翻，你需要翻译吗？
要，谢谢。
不需要，你随身 know me. Okay, I just stand back there.
I'm just going to summarize real quick. It's concerning the affidavit. Two things that the court would like to remind you of is that you should not be showing up with attorney in fact, unless you're licensed as an attorney. And number two is the affidavit should not have been filed without leaving the court, and that it looked styled as an opposition. If I could just address that briefly, and then Mr. Sachs, I think you would agree with what I say here. Mr. Sachs did reach out to me after he had received notice of the motion to continue, and he wanted to file the opposition. I had a couple of deadlines and did not respond promptly to the emails that were coming in concerning that opposition, as my intention was to oppose that opposition.
You mean oppose the motion?
Oppose the continuance and the motion,
Okay.
and then address the motion orally. That was what my intent was. So I think that Mr. Sachs, in abundance of caution, wanted to make sure that his position on that was going to be put in there. And those were several of the things that were going to be touched in on the opposition. As far as it being an opposition to the continuance, it is not styled as one. I don't think it can be seen as that one. But that was what the purpose of that affidavit was to get those things placed on there that he did wish to speak on in that opposition, due to the fact that I was working on a couple of different things and I did not make clear to him totally that I was going to be opposing orally.
Okay.
Now I could say that attorney, he answered that very well, and he's definitely on top of this because they have an obligation too, whether they agree with their defendants or not, which you should already know. But he's definitely he definitely did a good job on that. Okay, Sally, I saw what you just said.
In the future, then when he filed it, it should have been either something either as an attachment, and you could have done, defense hereby opposes, C, attached exhibit A for the reasons why. I mean, it can be that simple, but for him to file without your quote unquote blessing, if you will, is a violation of the rules. So I will leave it at that. And I think that, that has been adequately stated. Let's get to the crux of the motion. And I think what needs to be brought about is two things. One is that originally, one of the reasons why we continued the trial last August was so that Mr. Sachs could get an expert to speak on this issue. So I would simply say what's good for the goose is good for the gander as far as a continuation. And while I agree that the state may have been placed on notice that this was a potential theory of the case, just because somebody is placed on notice until such time as they actually get an expert report, there's no duty of the state to go out and investigate his theories of the case. That's his affirmative defense to prove that it was as a result of this gad millennium. They still have to prove the child abuse, neglect, and endangerment, but it's his obligation to come forward. They don't have a duty to do his investigation for him. And to the extent that there is a expert report that is being proffered, they have a right to get a rebuttal report. And just because that's somebody's theory of the case, until such time as an expert report is actually tendered, they have no idea what somebody is going to say. And I think what might be confusing to your client, respectfully, Mr. Goodwin, is simply because the state has doctors. It's a hallmark issue. Those doctors can't necessarily testify to the gad millennium issue. So it's not like they're going to be able to put these doctors on and your client or yourself is going to be able to ask them whether or not certainly you can ask them whether or not they are knowledgeable of this issue with Gadavist, I believe, or Gadvium and gad millennium. Certainly can ask them if they're not, but if they're not, they can't testify to it. And the articles that he's putting forward, until I have somebody that comes forward from the scientific community that says, yes, these are true, or those are authenticated, you and I both know those are hearsay. So they're not coming in on that respect. So until such time as an adequate expert has actually been tendered with an expert report, the state doesn't have an obligation to come up with a rebuttal witness. So I think in that vein, now that we have an expert, they have a right. This is not something that's common. They have a right to get a rebuttal expert to that, and they need to be afforded the same amount of time. But we're not going to continue it for an ungodly amount of time. We're going to continue it and limit it so that your client's rights are protected, because I understand that he does need to get to trial. But for him to, in his affidavit, to state that all of these continuances are the result of the state is not true. So that's my spiel. I will certainly hear argument from both sides, but my original inclination on this would be to grant the motion to continue the trial, but limited to whatever time the state puts on right now. And we're going to reset the trial now to whatever amount of time that the state feels. And then obviously, if you got the rebuttal expert report and you wanted your expert to be able to review it and see whether or not they wanted to do any supplementation, that would be appropriate as well. So that was going to be my inclination today, but I'm certainly happy to hear from both sides.
I was trying to let her get it all out first. And I think, so Mel, I see you asked a question about the interpreter. So the wife, believe, is not really fluent in English. So I think that's why they have an interpreter sometimes. And I think that was the only question that was there. But sometimes when the judge is just kind of going through everything, I hate to kind of break that up until she finishes. But this case has been going on a long time. So even before I just started following this case, I don't know what happened way back when, but I saw it moving from a certain point and just moving forward from there. So we're just all kind of like looking at it and checking it out.
It's your motion. So if you have anything to add, Ms. Renetti.
And I appreciate, and the court has kind of echoed my concerns. The one thing I will say is I did put in my motion that based upon there's two motions, a motion to continue, motion to discovery. And the motion to discovery is really important for me in the sense of I need to gather those scientific studies that the experts relying upon, because based upon my conversations I've had thus far with individuals in regards to this issue, I do believe I'll be filing a motion regarding whether or not this expert can actually testify regarding the scientific information that's the basis of his opinion. But at the first blush, I need to at least get those scientific articles that he's relying upon before I can file a motion for maybe an evidentiary hearing. I understand we don't do the Dahlberg standard, but something a little lower here in Nevada. However, I think there's, based upon my preliminary information that I've received, that motion will be forthcoming.
Oh, real quick. Cool Clearwater, thank you for the super chat. I appreciate that coming from Kathy. Thank y'all for being in here once again. And yeah, I really appreciate it. Thank you.
Well, and the other thing too is we also have case law that says that experts are allowed to rely on hearsay documents as long as it's the type of information that experts would generally rely upon. And so to the extent that you were to get a rebuttal expert and be able to provide whatever this expert reviewed to your rebuttal expert, you might not need to file that motion if your rebuttal expert says, oh yeah, I've reviewed these reports, and do you see what I'm saying? It might be something that you can just rebut as opposed to having to file a motion, but we're not there yet.
Not there yet. I will say preliminarily, I'm getting information that some of the science behind what this doctor is relying upon is not necessarily reliable. And so that's what I'm in the preliminary investigation regarding that.
Okay. Mr. Goodman.
Oh, Martin, I don't know how they film there, and I don't think this is a cell phone, not how fast they zoom in and out. I'm not really sure how it's done, but if you've seen prior hearings to this, you would definitely appreciate the resolution on this hearing, because a lot of the other ones look like it was from a long time ago. So I think they need some camera upgrades in that court. I'm not sure.
First, Your Honor, is the continuance. I just want to say a couple of things. I understand the court's position, but defense would not be opposed to granting the state some additional time to find that rebuttal witness so the trial can actually go forward, if that's what the concern is in terms of that prejudice. As Mr. Sachs has laid out a little bit in his affidavit, there is now a little bit of more of a serious hardship occurring to himself and his wife. Specifically, she cannot leave the country as the court's obviously in receipt of her passport, and she has not seen her family or anything like that for a long time. It has been a significant amount of time to be away, and she has not been able to make that. And I'm sorry, I don't mean to speak on that, but apologize, speak on that for your client, but for Mr. Sachs himself, he has been unable to find employment. He's got mortgages and other things that are coming out that he was really hoping to wrap the case, have it done so that he can go and see what's going to happen and move on with whatever's going on. So I think that there would be prejudice to the defense. And I think that giving leave to the state some time to find that expert and file it and not oppose that would alleviate that prejudice that they're facing specifically there. Because I do understand what the court is saying about doing a rebuttal report or a supplementation report. The reality is, though, Your Honor, that this is an appointed case. I don't know if we'll get approval for rebuttal reports and things of that nature based on that. So I don't know if I would be exploring that option, as we've just kind of barely gotten approval for this specific expert on this specific case. So there would be that prejudice there, Your Honor, and we would be opposing to it. Additionally, Your Honor, I think that as far as this case goes, we are kind of coming across to a very lengthy period of time. If any continuance is done, we would request a very short setting for a reset on this, because we do need to get this going, but we would be opposing that continuance.
Mr. Shetler, do you have anything to add?
Your Honor, I know that, I'm sure I'm going to address this. The concern is, and I did speak with Ms. Bernetti about my client traveling to see her family in China. There were some conditions put on that might be better addressed to you, Your Honor, and that's the primary concern by the delay. The paperwork that was filed speaks for itself, and you've covered the other issues, which is, I'm not going to repeat those. So that's our big problem. Is A, we need to get justice, and B, it's very challenging for my client right now because she can't travel to see family members, some of whom are ill.
And I know this court, and I don't want to push my luck. I'm in obviously, if the court mentioned, this is not a common thing that we see in criminal court. And so although I can set the trial now, I would like to at least be able to find the expert and then have their schedule. So I'm not asking for another continuance. The court that we give today doesn't work with that expert schedule. I'm in the process. I just need a little bit more time. I have to go through many different channels in order to find someone who can testify. There's no one here locally, so I'm finding someone. But that's my only concern. We just want to make sure that we can have that trial date, that we can make sure everyone.
So let me ask this question. How long do you need to find an expert?
If I could have like 3 to 4 weeks, and then in addition, I need to get that discovery from the defense's expert, and that may speed things up if I can get that discovery so that I can get that over to the experts as well. and file whatever motions I need to, because I think that will also require a hearing well before the trial date to flesh out whether or not certain experts and certain theories can be proffered during this trial.
I don't think you need 3 weeks to find an expert. I'm not saying that I expect you to have an expert report ready in 3 to 4 weeks. I think you can find an expert a little bit faster than that. Obviously, you've already started looking and made some inroads. So my inclination would be, let's see here.
Well, she doesn't want to wait that long because this case has been going on a long time. But yeah, I'm sure they should be able to find someone rather quickly at their disposal.
You're currently at the 5th.
This may help or it may not.
Sure.
Mr. Eddie and I spoke. I didn't get a chance to speak about it with co-counsel about possibly scheduling an evidentiary hearing on that in case we run into expert availability issues with a trial date. Probably premature, but something to at least keep in mind possibly.
And I'm sorry, what are we talking about evidentiary hearing for?
Potentially a motion to strike your expert.
I will.
My thought being we could maybe clear up a complicated medical issue that might be able to have something tight to give to the jury one way or the other. That could be completely incorrect, but it was something that had come up.
And Jordan, I haven't spoken to the discovery motion. I was only speaking to the continuance. I still had things on the discovery motion.
Okay. Let's talk about the discovery motion then. Go ahead, Mr. Goodwin.
Your Honor, some of my concerns with the discovery motion was a very broad ask of materials that had been requested in that discovery motion. My understanding from this is that what was provided to the doctor was the doctor reports that were disclosed on the evidence, and Mr. Sachs, a conversation with Mr. Sachs. Now, the reports, the studies that are reported on, I'm not sure if it's defense's job to compile everything that this doctor used to gain knowledge about these situations. I'm not sure that that's something that is even something manageable in terms of discovery and whether or not I can provide that type of discovery. He has a very specialized set of knowledge. He spent years owning his craft and doing all these other types of things. And now to say, okay, well, we need everything that he relied on to make that determination in terms of studies, that's a huge ask, and that's an overwhelming ask, in my opinion. If they can find an expert who can speak on it, they'd be familiar. They should be familiar in those areas, or at least know exactly what he's talking about to say, oh, no, that's not true, or that is true. So that's a big ask. And my other concern is, and looking at this issue, is if we're talking about the things that he relied on, well, parts of those are statements from my client. And I don't believe they're entitled to that. They were never reduced to writing. The report is what was reduced to writing, and that has been turned over. So I don't think that we can compel my client to be giving that. And I don't think that we should be asked to create discovery for the state. I don't think that's what our obligation is in any way or more with our requirement. So in terms of what's being asked for, it's mainly what they're looking for is for us to go back and speak to that expert, say, hey, where's all your knowledge about all of this come from? And then provide that. And again, I think that what we're doing there is compiling and creating discovery in this case, rather than have discovery that would be turned over. So I don't think it's an appropriate motion at this time. Just like if we had a firearms specialist, what would be asked for in terms of reciprocal was, what reports did you rely on? What are your certifications? And we provided all the certifications and we provided the report. So I don't know, I'm not entirely sure what exactly in there would be required, because the things that he relied on to make his report were that doctor's report and conversation with Mr. Sachs.
Okay, I'm going to, and I'm sure your client later on is going to say, you need to challenge her on this point, and that's fine. However, criminal rules are not as up to speed as the civil rules. So let's talk about what's required for experts under the civil rules. And I'm going to make an analogy to those civil rules as to what I think needs to be disclosed, because I agree with you in part that his statements to this expert, especially if the statements are as a result of things that can be found in the medical records themselves, are likely not discoverable. However, if you look at Rule 16, Nevada Rule of Civil Procedure, Rule 16.1, 16.1, and it's A2, disclosure of expert testimony, and specifically under B. And it says the report must contain a complete statement of all opinions the witness will express and the basis and reasons for them. 2, the facts or data considered by the witness informing those opinions, any exhibits that will be used to summarize or support them, the witness's qualifications, including a list of all publications authored in the previous 10 years, these other ones, a list of other cases, and then a statement of the compensation. I don't think that those are necessarily what I'm talking about. Is 2 and 3. So the facts or data considered by the witness informing his opinion and any exhibits that will be used to summarize or support them. If those are contained in his expert report as to what he utilized, I would agree with you that then the state can look those up. Their expert can look those up. But if those opinions, if it's just his opinion without the basis of that expert testimony and without the exhibits that are going to be used to summarize or support them, then he needs to provide those. The expert needs to provide those. And that's what's going to be my holding on that.
Somebody did mention in the comments that going through all of this technical stuff, they can have the trial. But unfortunately, this is the way it goes because of all the motions filed previously and they had to get the court-appointed attorney. They have to go through these processes to get back to where they were before, which is trying to get to the trial.
Mr. John. So, and I'm sorry, I just want to get some clarification.
Sure.
To make sure that I don't do any civil, and we'll see what's going on here. So, I'm looking at 16.1 now, and you were saying which ones should I be?
16.1, A, little a.
Uh-huh.
So 16.1, little a, 2, B, I, and I.
We have a brief court's indulgence.
Sure.
And Judge, I would also include State v. Judicial District Court. It's a 2012 case. I can give you the site if you'd like it. And it talks about in the context of an expert opinion testimony or jurisprudence recognizes the need for disclosure of facts, data, or other information upon which an expert opinion is based to facilitate meaningful cross-examination.
And also under Hallmark v. Eldridge, you have to look at, they have to meet certain qualifications. And those qualifications include that their opinion is subject to peer review or has been tested. So to the extent that he's relying on reports, if his reports have not been subject to peer review or have not been tested, that would be a factor of going against him and his ability to be able to testify under Hallmark v. Eldridge. So
I understand, Jordan. And I think that according to what my understanding is, I think that all of those, the exhibits who used to be summarized or support them, we have not discussed him bringing any exhibits or showing those to explain how this works. So he wasn't intending to introduce any exhibits.
okay.
And then as far as.
But the facts or data considered by the witness informing his opinion.
Right, so that would mainly be the medical report from YL while he was in the hospital, as well as statements from my client. So.
Okay, to the extent that there is anything else, because it's my understanding from reading your client's affidavit that he has all of these articles that were provided to the doctor. If the doctor is utilizing those articles to support his opinions, the full panoply of those articles and not just portions of them, we're not talking about, the Cliff Notes versions, but all of that needs to be provided to the state.
I will reach out to the expert then in that's the case, Your Honor. Just because he provided them does not mean that the expert relied on them. So I will speak with him about that. I understand. Okay. I understand that, Your Honor.
I do believe in throughout his expert report, he talks about studies, and in particular, he talks about something out of Ontario, Canada that he was relying upon. Okay.
So that's what I'm saying. Yes. So anything that's contained within his report that is not attached to his report and doesn't have the name of what it is for the state to be able to find it on their own, needs to be provided to the state. So if it says, this is a quote out of Black's Law Dictionary, or if it was a Westlaw citation to a case, you would give that Westlaw citation so that the court or yourself or the state would adequately be able to look it up to see whether or not it stood for the proposition that it is being utilized for. It's the same thing here. So if there is a citation to something that he is using that doesn't have a full citation that would enable either the court or the state or even yourself to be able to look up that document to make sure that it actually is what it purports to be, then that needs to be provided.
So
Okay?
essentially 16.1 compliant.
Yeah. Mr. Shetler understands because he does civil. All right. I think I'm going to give you guys until February, the state rather, February, the end of the day, February the 28th, to at least provide and get the name of an expert. And then we're going to come back that following Monday, March the 3rd, to make sure that we are on track and reset the trial date.
And Your Honor, may I just make a brief record too, just on the
Of course.
discovery really quickly. I'm sorry. I understand the court's ruling. I'm not trying to argue any further.
You are fine.
To the extent that the NRCP is being used as a standard for the expert, I would just object.
And that's fine. To the extent that there is not a lot of other guidance as to what we need to use for the expert other than Hallmark v. Eldridge, which I would say that under Hallmark, as I said, one of the factors to be looked at is whether or not the information that is being provided is subject to peer review and has been tested, in order to be able to have your expert not stricken. They have to meet all of the qualifications under Hallmark. And so therefore, I think it is equally as provident under Hallmark to be able to make the ruling that I'm making. I'm just thinking it's easier to refer because there's an actual rule under 16.1 without having to be vague and ambiguous as to what Hallmark requires.
Thank you, Your Honor.
You're welcome. So March 3rd, let's come back. We are going to vacate the trial. Right now, we will come back on March the 3rd to continue the trial date. At that March the 3rd hearing, what I'm going to want from the state is how long their expert, so i.e. at that point, you should have talked to your expert and found out how long your expert is going to need in order to prepare a report. The defense will have turned over anything that the court has ordered as a result of today's hearing to the state by that point, so that the expert has the ability to make that time frame analysis. And then I want both sides to come prepared with their calendars to reset this. I'm not going to go that far out. I may give the rebuttal expert 30 days to do a report. So we're going to be looking at sometime, I would say early part of May, early middle May.
And we have a copy of the court stacks.
If they want to email me, I can email you guys all this stuff after court availability as well.
Okay. So, but have your calendars ready for May and June, because I will set something for sometime in that time frame.
And have some expert availability for those types as well.
Exactly. Okay. Anything else that I can at this juncture?
I need to make a record, Judge.
You are not allowed to speak, sir. You are represented by counsel. So
If other judges did that on some of the other cases we watch, yeah, that would be nice and quick.
if you would like me to leave the room, I'm happy to leave the room. You can talk with your counsel and then your counsel can make a record on your behalf. So I will do that now. Mr. Goodwin, you can go call your client off the record. Mr. Goodwin, you can go call your client and see what he would like to say, and then you can make the representations for him.
Thank you, Your Honor.
Off the record. Okay, back on the record in C 343540 and 343540, 1 and 2, Zhang and Sachs. And Mr. Goodwin, have you had an opportunity to speak with your client?
Yeah, Your Honor, and there are 4 things Mr. Sachs would like to do.
Okay,
first was touched on a little bit, but he wanted to emphasize this, that he believes that his inability to work and the financial hardship caused by this trial is now bordering on cruel and unusual with the time that it is coming along. So he would like to make that known and the record that he believes that he's crossing into the cruel and unusual punishment due to the length of time the case is doing in his own personal financial situation.
Okay, I will address that. We'll address them one by one. As I said at the very beginning, to the extent that he asked for the continuance in order to be able to obtain this expert, and the trial was supposed to go back in August. It's now January, so August, September, October, November, December, that's 5 months that he was afforded the ability to be able to get his expert. The state should receive the ability as well to obtain a rebuttal expert. So to the extent that he in part caused the issues that he is now complaining of, the court disagrees. Okay, point number 2.
Understood, Your Honor. Number 2 was just he would like the court to be on notice of potential civil rights violations and pending litigation. Pursuant to those.
Okay.
Number 3, Your Honor,
And I don't know what you mean by civil rights violations. If you're talking about anything that the court has done, this is, as you know, anything that arises out of a judicial decision that's made by the court is not subject to a civil rights action. So,
understood.
Okay.
Number 3, he would like to correct one more issue. He did not, in his affidavit, attempt to blame the state for the multiple continuances. He stated that was a misreading of his. He did not say that the state was the reason for the continuances. And I know from speaking with him personally that I think he realizes that he was the one who requested
okay.
the multitude of continuances.
Okay.
Number 4, Your Honor, I spoke with Mr. Sachs about this yesterday, and this is why I did not personally bring it up. He's concerned about the motion to continue not being compliant with the rules of criminal procedure in terms of what was attached being an affidavit instead of a declaration. I
RS 53.045 allows an declaration to serve as the same place as an affidavit would.
And I also told him, Your Honor, it could also be corrected by her simply swearing in and a motion's not even necessarily required for a continuance if they're sworn in and good cause is found.
Right.
So I think he still hit that, but he did like to point that out that it wasn't compliant.
And I disagree. Again, NRS 53.045 allows a declaration to be used in lieu of anywhere where an affidavit would be required.
Understood, Your Honor.
I did want to bring up, and I don't know if you all want to deal with it orally to the extent that it was hit on a little bit, of the ability for Ms. Zhang to travel. Is that something that has been addressed by both sides? Is it something that we need a ruling on? Has there been a resolution? Where are we at?
Ms. Renetti, thank you, Your Honor. Ms. Renetti had stated that she would not oppose travel as long as Ms. Zhang was able to sign affirmatively make two
Swear under
statements.
oath.
And when I spoke to my client, it gets confusing. There was some confusion on that part, and I don't know. I understand where Ms. Renetti's coming from on that. It might be better in writing. It might.
And we might come to an agreement if we can. And
Okay. If there's an agreement, then I will abide by whatever the parties agree to on that issue. So if you want to submit a stipulation in order on that issue, I will abide by that. I will say that in other cases where I've been pending trial with somebody, it was simply, you need to check in before you leave. You need to check in when you get back, and something needs to, and you need to provide, the date and times of your travel and when you're leaving and when you're coming back, so that if they don't come back at that point, I believe that, where would she be traveling to? Would it be China or?
In China,
Okay.
I'm not sure which province, Your Honor. I'll find out. And certainly that's nothing, that won't be, I'll talk to Mr. Renetti. So far, it's just been some details.
I believe or extraditable in China, but I'm not sure. No. Okay.
so that's one of the.
That's a little bit of an issue.
Yeah, so we're trying to work around a
Okay.
couple things, and there were some things about requiring something to be under oath for, issues. And then there's one other issue. We can
Right.
talk about it if it
Okay.
becomes, there's just two stipulations I wanted.
If you all need to bring a motion in regards to that to my attention, I'm happy to do that on an OST if it needs to be done. Certainly I would want good cause. I understand that people want to see their families. I get that. But, if there's very specific, if there's, a family member that's ill or something of that nature, that obviously has more pressing need than simply, I haven't seen my family in 5 years.
I understand.
So,
Thank
All
you
right,
for that.
thank you very much. Is that all?
The status check is gonna be set for March 3rd at 9:30.
9:30.
All right.
Thank you.
Anything else for purposes of today?
Okay.
All right, thank you very much.
All right. Well, we got through that hearing, and that's an update for those who have been following it. And if not, you'll be able to see other ones on the channel. So now we're going to Judge Webster's court. And I want you all to kind of take a look at this case. You may have seen it already. It was just recent. But Judge Webster had a different attitude in this hearing. I was really shocked by what I saw in this one. So let's check it out, and we'll evaluate it in the comments. Let's go.
Will be on the record on Rihanna Johnson, BU 2025 TR 1899, State of Kansas versus Rihanna Ray Johnson, Jared Regier for the state. Rihanna Ray Johnson, that's you appearing in person in pro se.
Yes, ma'am.
Ms. Johnson, you're charged with count 1, driving while suspended, a B misdemeanor. You're charged with driving without proof of insurance, a B misdemeanor. Well, may I correct that on number 2, you're charged with driving without insurance after a prior conviction for driving without insurance in 3 years. That prior elevates it to an A misdemeanor. You could be looking at a minimum fine of $800 up to $1,000, and you could be looking at up to a year in the county jail. How do you wish to proceed on the issue of an attorney? Do you wish to have an attorney or,
Yes, I would like to get a court-appointed attorney.
all right, are you employed at this time?
Am I what?
Are you employed? Do you have a job?
Yes, I do.
Where do you work?
Premium retail services.
What do you get paid per month?
It varies, but I average probably like 30 hours, about 25 to 30 hours.
What do you make per
And-
month?
I make $13.50. Oh, I mean, $13.50 an hour.
You make $13.50 an hour at 30 hours a week. Is that what you just said?
Yeah.
But you don't know how much you make per month.
Well, it varies so much, but I average it out to be about 30. So
Are you saying about $405 a month? Does that sound right?
I'd say it's probably a little more, like about 600.
All right, and what do you pay for? Are you married or single?
Single.
Do you pay rent?
Well, that wouldn't be per month. That would be that's a week. Like so that would be,
About
600.
$2,400 roughly.
yeah.
You're saying
So that
$600
was
a
like
month?
No, not a month. No. That's why I was like, wait a minute. Yes, I pay rent and
How much per
electricity.
month? Tell me the amount,
600.
please.
600 in rent. I don't know on the other because I had just moved in, so I'm guessing maybe like 200 in electric and 100 in gas, maybe.
Any other expenses?
I have a cell phone. My child support.
Will you
My
have
cell
to tell
phone
me the
is
amounts?
my cell phone is like $240 because I pay for my kids' phones.
Okay,
And
but you don't
then
have to, hold on, you don't have to pay for your kids. How much is yours?
how much is mine? Mine is like 120, I believe, because I have internet with it.
Okay. And you said some other figure, what was it?
I have child support.
Do you pay that child support?
It is like 370 something a month.
Do you pay that or receive it?
No, I pay that.
But you're not sure exactly how much?
I think it's like 167 per check.
What else do you have, if anything? Car payments?
No car payments. Insurance, I don't have that yet because I'm not driving, but I have to get an SR22, so it'll be quite a bit. But
You
I don't know what else
that's gonna be?
what else you claim. I don't know.
But you don't know what your car insurance is gonna be. You haven't talked to anybody about that? For your
Yeah,
SR?
it's pretty high. It's going to be like $190 for liability on my car, and that's a month.
You said child support. How many children are you supporting?
3.
So your family of 4. All right, I'll find you qualify and appoint attorney Darren Patterson. Have you taken down his number yet?
No.
Darren Patterson, Darrem Patterson. His number is
Okay.
316-322-7700. Call him today. That's an order. Come back with him ready to go. And the next court date for Darren is when?
Your Honor, that is January 12th.
January 12th, 8 a.m. You have to be back.
I didn't catch that because somebody else was talking. What was that?
Well, it's January 12th, 8 a.m. You have to be back here by Zoom, ready to go with Mr. Patterson.
Okay.
And Your Honor,
Mr. Regier.
some new information has been brought to my attention recently regarding this matter. If I may request a brief 2-minute recess.
Granted.
Thank you, Your Honor.
You're welcome.
Something just downloaded.
Thank you, Your Honor.
You're welcome. Back on the record in BU 2025 TR 1899, State of Kansas versus Rihanna Ray Johnson, all parties as before. Anything further, Mr. Regier?
Merely that the state wishes to be heard on the issue of bond at the appropriate time if the court is making such an order.
This is the appropriate time. Please proceed.
Your Honor, in addition to the 2 charges currently before the court, both of which the state considers considerable, especially in light of count 2 being charged as a Class A misdemeanor, the state is recommending a bond of at the very least $3,500. The state does not oppose the court ordering an OR bond, given that the defendant appears in the fashion that she does today. Besides the charges currently before the court, the state understands this is a defendant with at least 1 prior driver's license violation, a diversion for DUI, as well as at least 1 non-traffic felony conviction. Under those circumstances, the state does respectfully submit that $3,500 is appropriate.
I have a question
Go ahead.
on that. The DUI, I haven't received a DUI. I don't believe like I've received one. When did they say I had a DUI on that?
I didn't hear a date or time. I can look and see what I have. The record you have that I see for Odyssey starts with speeding in 2004, and then it jumps up to 2000. Well, that's a different kind of matter. You have a 2013 criminal for damage to property, interference with Leo, law enforcement. But it looks like the conviction was for criminal threat.
Yeah, I knew that. That's been like 12 years ago. But I don't recall ever getting a DUI.
Well, I'm looking for that. In the meantime, Mr. Regier, what year do you show that for her benefit?
Your Honor, in response to the court's inquiry, it does appear to be somewhat dated. Nevertheless, given the nature of the offense, the state does consider it relevant for purposes of setting an appropriate bond in this matter.
And when was it dated, you said?
I don't see it on her Odyssey, so it may not have been in Kansas, but how long ago was that? You said somewhat.
Approximately 20 years by the state's understanding, Your Honor, per the court's inquiry.
20 years. 20 years. So I don't even recall ever getting one 20 years ago, but so you bring up something for 20 years ago?
Sure he can.
I mean, I don't recall ever getting a DUI 20 years
Well,
ago.
No, I don't see it on your record. I'm not going to consider it, but for all the other reasons
Thank
he
you.
stated. For all the other reasons he stated, 3,500 OR sounds reasonable, and I am going to make that your bond.
And why is that? Just because I have
Well, because
driving
you
with
have
suspended?
you have a lengthy record, ma'am, from starting in 2004 up current, keeping it up till now. 2013. Do you want me to go into all of these? They're
I mean, I don't have,
criminal charges.
but that's been like 12 years ago and has nothing to do with my driving, like record.
Well,
Now it's been going pretty good so far. Just check out how things may amp up.
your record has something to do with your record.
That's one felony. That's all I have on that. Like, I mean, I'm not trying to argue with it, but I don't have a really extensive record except for a couple driving on suspendeds. Like, I mean, I really don't.
Well, I'm giving you an OR bond. That means you don't have to put the money up, and I'm not going to go there's not much less I can do on that. I could say, oh, well, 500 OR, and I'm not going to do that. You've got a long record here of different kinds of activities indicating to this court that you could be a flight risk. And so your bond is set at 3,500 OR. You may not like that. You may not approve of that. If you find yourself some kind of appeal, avenue, you can try that. But that's your record at this time. That's your charge at this time, and that's what you've also had a failure to appear in this case, Miss Knoxted. You failed to appear April 23rd. In this case.
This case, not this one because I just
I'm
got
sorry.
this 2 months ago.
My apologies. I was looking at Knoxted's and you're Miss Johnson. Let me look at that again.
Okay, because I'm like, I'm not.
Okay, let me double check your screen. That makes a lot of difference.
Well, that was a close one.
It actually makes it worse because now you've got driving while suspended. Okay, you are Rihanna Ray Johnson, correct?
Correct.
You have driving while suspended and driving without proof of liability insurance after a prior conviction of driving without insurance within the last 3 years. So you've got an A misdemeanor, a B misdemeanor.
Mm-hmm.
Mm-hmm.
And you've had Mr. Patterson, but you apparently didn't go over and contact him like I told you to.
To who?
Darren Patterson. Are you saying
I haven't done it yet because you just now told me to today.
All right.
I mean, I'm still in court, so I can't call while I'm in court, right?
Right. Now, Miss Johnson, you better calm down because you're not going to do yourself any favors here. But here's your record. Going back to your record, 2004, there's speeding.
Mm-hmm.
There's some children involved in some cases that I won't use.
But that's irrelevant with this.
All right,
I mean,
look. Okay, are you going to let me be the judge and tell you what's relevant and what's not, or are you going to just take over the case? You want me to just give over and let you want the case? I'm not going to give it
but you don't have to be rude to me. I mean, but I don't know what my children have to do with me driving on suspended.
I'm not going to stand here and let you, or sit here and let you talk down to me like that when you're the one that's accused of violating the law, and then you come in here with an attitude trying to tell me how it's going to be.
No.
Stop.
Judge Webster just snapped on her. She's not playing today. Oh, I see that. See that cool Clearwater popcorn time. Definitely, it is right now.
No, but you're bringing my children into it for why? My children have nothing to do with me driving on suspended. They have nothing to do with that. None of them cases do.
There you go.
All right, your objection is noted, overruled. Now then.
Okay, I'll just come back with my attorney.
All right, are you hiring your attorney or are you applying for your court-appointed attorney?
I'm applying for the court-appointed one like I had asked prior.
All right, and you're going to go over and you're going to talk to Mr. Patterson. And I suspect the first thing he's going to tell you is show some respect for the court, whoever the court is. You don't have to feel respect for me, but you have to show respect for the
I am showing
position
respect,
I'm
but you're
in.
being disrespectful to me.
Whoa.
Like, I feel like you're being very disrespectful to me.
Now let's finish looking at this record. I've told you, you want me to make it a cash or surety bond? Because you're starting to show me an attitude that I don't know that you respect the court enough to follow the court's orders.
I do respect the court.
Let
Now, do you think she was that bad to Judge Webster? I mean, yeah, she got a little upset about the children being mentioned, but I've seen worse than this, and I've never seen Judge Webster go off this fast ever, unless I missed the case. But I never seen it, so let me know in the comments what you think about this one, because this is definitely interesting.
you just don't respect me personally. Is that what you're saying?
No, I do respect everybody. I respect the court, but I feel like I'm not being respected at all. And I'm not being disrespectful. I really am not. I'm just saying that when I object to like some of the things that you were saying, that's all I was saying. But I will keep my mouth shut and you can proceed and I will come back with my attorney, like court appointed attorney. I apologize.
May I speak?
Oh,
And I'm being sarcastic and I shouldn't be. That's out of order. And I correct that. But you are provoking the court, Ms. Johnson, and you need to stop it. Now, pending, besides the case you have in front of me right now, you are charged with Sedgwick County District Court. You are charged in 2024 driving while suspended. That's still open. You've got a Harvey County case, driving while your license is canceled, suspended or revoked, driving without insurance. Familiar? That's what you're looking at in Butler
I
County.
just actually found out about those two cases today when I called to see where my court was today, because I didn't know about the one that I didn't know I had two open cases and one in Harvey. It's because I owe fines to it. That's it. And then the one in Wichita, Central County, I owe fines to it. That's the only reason they're open is because I still owe my fines. That's it. And I need to pay my fines.
So in addition to driving while suspended and driving without insurance after a prior conviction with 3 years, you have an open Harvey County case in addition to the Butler County one. Then you have the Greenwood, a limited case in Greenwood. You have a BU, that's Butler County, another, let me see, maybe that's, okay, that's the one here today. I have other things. 21 CR, criminal use of a financial card, theft of property. I'm sure you're going to tell me those have nothing to do with your traffic. But it tells me that you don't follow the rules, you don't follow the laws. Here's a traffic in 2018, speeding, operating without a valid license. 2015, driving without liability insurance. More civil matters.
And I have a question whenever you're done.
I'm not done. I've got to get past some of these matters. What county, Mr. Aguirre? I can't think of what county VA would be, but there's a criminal threat. There's a criminal damage to property 2013 and interference with law enforcement, criminal damage to property again, criminal threat. It's on your record, ma'am. You can talk to your attorney about it. But these are all matters and they keep going. There's a.
How far back do you guys, use that against a person? I thought it was like 7 years.
I don't know where you heard it 7 years that I can't use anything you've done after 7 years, criminally speaking, but I have never heard that law. They didn't teach me that in my law school. Maybe they did in yours, but not in mine. Ma'am,
I was just asking a question. You don't
I'm
be rude.
going to
I was
answer
asking
your
a question.
If you will let me, I'm really trying to stay calm and not find you in contempt. But the way you are sassing and disrespecting and arguing with the court puts you in a position where I could find you in contempt, order you to pay a fine, and actually order you to serve jail time. I don't know if you're aware of that from this long history, but let me tell you this. Your history, I can consider your criminal history as far back as you started committing criminal history and establishing it.
Now, one thing I mentioned in other videos that a criminal history is like a credit report. Once you start building that file, they go back to it and look at everything.
Oh, I
Yeah.
didn't know that. I didn't know that. I'm sorry.
Well, I'm sorry you didn't, but now you do know that when you started establishing a criminal history, it became a basis that future courts could look at to determine whether or not you're a risk to come back to court, whether or not you are at risk to the community to keep violating the law. And that is why I'm going through this record. I probably wouldn't have scrutinized it as much other than you've challenged me, you've questioned me. And so that's what I'm looking at. And I think that I think it's very reasonable that the state recommended, and they've got more traffic matters, it sounds like, than I do I'm just looking at your Odyssey state record that's through the state computer system. He has the whole official KBI, FBI records that I don't have. And from what he said, he has more than I do. And yet he has restrained himself to recommend only a $3,500 OR bond. And because he recommended that before, but turn off whatever it is you're causing feedback, whatever you're recording me on. Because
I'm not
She sounded like me. She said, huh?
recording you on anything, ma'am.
I have a very busy docket, ma'am. I really need to get on. This isn't fair to the other people that are politely waiting their turn.
Okay, but why did you accuse me of recording you? Because I'm not recording you at all.
You turned on a TV, you turned on a computer.
I don't have a TV in my home. I don't have a TV in my home. Would you
All
like
right.
this? I don't. I really didn't turn anything on. I'm sitting right here and I don't have a TV. I don't own one.
Ma'am, you started causing feedback. Your recording device started causing feedback. And that is usually because someone turns on another device. All right, Miss, I have got to get on with that. Would you just stop and listen to me?
Yeah, but I didn't do anything like you're accusing me of. I really didn't.
Okay, one more response like that, and you're going to be found in contempt, and I'm going to issue a citation to have you picked up and put in jail. Please do not force me to do that. I don't have time to do the paperwork to do that today. You can see this docket. I've got a full afternoon docket, and I want to give everyone their due rights today and their due hearing.
I know after her, if I was next, I would ask for a continuance. And on top of that, wouldn't it be messed up if one of them unmuted themselves for a second and had some kind of feedback and then muted themselves back? As mad as she is with this lady, she would get the charge for it.
All right, now your bond is set. No arguments allowed at this point. $3,500 OR. You will go into a breakout room as soon as this hearing is over. There will be an invitation to a breakout room flash on your screen. You will go into the breakout room with court security too. They will set up a time with you to go out to the jail and take care of your picture, your prints, and post that OR bond. You do not have to take the money with you, but you have to sign a document that if you don't come to court and do what you're supposed to on that bond, you can forfeit that bond, causing the money to end up in the state's hands, and you can cause a warrant to be issued for your arrest. So that is your bond. And tell me again, Jenna, her next court date.
Your Honor, I have January 12th at 8 a.m.
Oh, real quick, if you ever notice Mr. Regier, he makes those same slight head turns from side to side as if he's like analyzing everything, which I think is pretty cool.
You must come back January 12th, 2026 at 8 a.m. with your attorney and ready to proceed. Mr. Regier, is there anything else I need to address?
No, Your Honor.
All right, Ms. Naxted, anything, or I'm sorry, Ms. Johnson. Ms. Johnson, anything else you want to take up before I let you go?
No, Your Honor.
All right, then I suggest you call Darren Patterson, your court-appointed attorney, and let him know what's gone on today.
I will. Thank you.
You're welcome. And put your face back on your screen. Where did you go?
I'm right here.
All right. And next time I see you, next time you see any judge, and you've seen a lot of them over the years from this record, next time you see any judge, you need to show the judicial process a better appearance, a better kindness, a better courtesy than what I've seen today. Maybe you think it's courteous, but it's not, trust me. All right, you may go at this time, Ms. Johnson. You are excused from today's proceedings. Continued on that bond.
Your Honor, does she have to be in a breakout room before she goes on?
Yes, she does, please. Ms. Johnson, no, you're leaving me, but you're not leaving the recordings. Go see the court security officer. Thank you, Jenna.
That hearing was something. And what I put the poll in there, so most of y'all voted that, yeah, the lady, yeah, she deserved what she deserved, basically. But that was something. And I think Rhonda in the chat said that she's seen worse. I covered some cases with Judge Webster, but I haven't seen her go off not like this. It just seemed like, I don't know, maybe because the docket was full and she might have been stressing over that, but she picked up on that lady fast. That lady didn't have a chance. The couple of questions she asked put her right in trouble. So that's the last one I had for the night. I was just trying to catch up because I know I didn't give y'all anything in a couple of days. So we're gonna get moving this week. I'll see if I can do some more lives this week. So thank you everyone for showing up tonight and hanging out. So I hope you enjoyed both videos. And don't forget to give it a thumbs up on your way out if you didn't already. If you liked it. If you don't like it, don't give it a thumbs up. But but anyway, thanks for stopping by. And I will see you all on the next one. All right. Have a good evening or daytime, wherever you're hanging out at. But I'll see you soon.